Get one more joined on, we'll get started. We have a full agenda today. Oh, looks like Representative Wheeler just joined us. So with that in mind, I think that we should go ahead and get started. Chairman Jennings asked me to conduct this meeting in his absence. If he is able to join us a little bit later, we'll turn the reins over to him. So with that in mind, we'll go ahead and get started. I believe that we have a few bill introductions. Clint, if you want to go ahead.
Thank you, Mr. Vice Chairman. Yes, Clint Blaze on behalf of the Attorney General's Office. I have three bills we would like to request on behalf of Attorney General Schmidt. The first one is 21 RS 0199, and that relates to state habeas actions under 60-1507. The second one is 21 RS 0202. That one deals with criminal history issues on appeal. And the third one is 21 RS 0203. That one increases the penalty for mistreatment of a dependent adult when it occurs in an adult care home.
Excellent. Thank you, Clint. Committee, any objections to the introduction of those bills? All right, not seeing any, we'll consider those introduced.
Thank you.
Any other bill introductions from anybody today? All right, I'm not seeing any hands raised. So with that in mind, looks like our first hearing is going to be on House Bill 2077. So with that in mind, we'll go ahead and open that hearing. And Natalie, if you'll give us an overview on that, I would appreciate it.
Thank you, Representative Owens. House Bill 2077 would extend the Kansas Criminal Justice Reform Commission, limit its scope of study, and add a public defender to the commission. So the bill amends KSA 216902. That's the statute that created the commission. It puts a couple other areas of study in there. So it requires the commission to analyze diversion programs and recommend legislation that requires both pre-filing and post-filing diversion be available in all counties. That legislation should also establish minimum standards for diversion and provide for a method for removing diversion records from a person's criminal records. It would also require the commission to discuss and develop recommendations for legislation to establish research-based standards for community supervision programs. They would want those to provide incentives to earn early discharge from supervision, create standard terms and conditions for supervision, create effective responses to behavior through incentives and graduated sanctions, and also provide a means to consolidate concurrent supervision into one agency. The bill also removes some of the current study requirements from the commission, namely those that the commission has already completed its study on, which are specialty courts, surveying the availability of evidence-based programming, studying the placement of offenders within the Department of Corrections into specialty facilities, evaluating information management systems, and to study other matters. The bill would also add a public defender to the commission, and that public defender would be appointed by the executive director of the Board of Indigence Defense Services. And then it would create a new final report deadline. Currently, their final report was due December 1st of 2020. And so now with this extension, their new final report would be due December 1st of 2021. And I can take any questions.
Excellent. Thank you, Natalie. Committee, any questions? All right, not seeing any hands raised or anybody going unmuted. We'll go ahead and go into our testimony. I believe we have Mark Bennett, Chairman of the Kansas Criminal Justice Commission, on board with us and ready to go. So take it over, Mark.
Thank you. Thank you, Steve. Thank you for the opportunity to be heard today. First of all, I'm double check. Can everybody hear me and see me okay? Getting a thumbs up, okay. I'll try to keep this fairly short, but as all of you know, the 2019 legislative session put the Kansas Criminal Justice Reform Commission into place with House Bill 2290 from that session. And lots of us on the commission, including Representative Owens, myself, members of the judiciary, defense attorneys, a couple of prosecutors, including myself, law enforcement, corrections, just advocacy groups, a cross section of the folks who have a hand in the criminal justice system in Kansas. And we spent the second half of 2019 putting together an interim report, spent all of 2020. We all got very adept at Zoom and WebEx so that we could do this. And I was pleased to say that despite the pandemic and the difficulties that brought, we were able to put forth a very extensive report. And I would say the quick thing to take away is that at the end of 2019, we had identified a number of bills that we thought we could do some immediate good. We've referred to them as kind of low-hanging fruit, things that were not particularly controversial, but would make a substantive impact in the criminal justice system in Kansas. Through no fault of anyone's, the 2020 session, that I think every bill we proposed got through the House. Most of them almost unanimously, if not, I can remember one bill, I think it was 124-1 or something. I mean, it was very well received, and I had every expectation and every reason to believe it would have been equally well received by the Senate. It just, the pandemic shut us down. So that kind of changed the way our final report, which at this point is the final report of the commission, that sort of changed the way we approached that for December 1st of 2020. And that is, we didn't get things done that we hoped would kind of get us further along. And so we re-urged those same bills, knowing that to ask for 20 or 30 bills to make up for what happened in 2020 and take up the balance of our efforts was probably too big of a lift, especially in this year when you got a year's worth of work to catch up on in the session. So I think we took a fairly conservative approach here. We submitted, I think, 6 or 8 bills. You're going to hear, I think, even yet today, at least two of them, some of which were Reform Commission bills, some of which we simply endorsed that came out of other, Sentencing Commission or KDOC or something. But so rather than just barrage the legislature with a ton of specific bill requests, in addition to the ones that were carryovers from last year, instead we identified about 50 topics which we believe needed to be identified as important issues, and urged the legislature over the next several years to take them up as time allows and wrestle through the public policy implications of each of these topics. To assist in all this, our final request was that I think this commission needs another year. Not for everything necessarily, and talk to Representative Jennings about the scope of this, and that we, in talking this through, tried to limit it to these, I guess, 4 main topics with several subtopics of number 3 and number 4, but things that we could do so we could continue this work and at least put the legislature, either realistically the 2022 legislature, 2023 legislature, in the best position to do some good. And I made reference finally in my written testimony. I hope you all got it. I sent it yesterday. The 3R committee from 2006 did a ton of work, and their work is still out there and you can get access to it. But they only got through really essentially one leg of the 3 prongs approach that they took. That was the recodification. And I would just hate to think, well, let's put it this way. If everything they wanted to accomplish in 06 had been accomplished, maybe if that committee had stayed a little longer, worked another year or two and put things into a better position for that legislature, 14, 15 years ago, I don't know what position we'd be in today. And I wonder if the Criminal Justice Reform Commission of 2019, 2020 would have been as necessary. I don't know. I mean, that's an impossible question to ask. And all I'm getting at here is I would hate for all the work we've done in the last 18 months to be in this great report that identifies everything, but kind of loses steam, as legislatures turn over. So those are the reasons, in a nutshell, why we want to do a little bit more work, extend this for another year at least, so we can put you all in a better position to at least have before you more bills that would be the product of our work, and hopefully put the criminal justice system at least in a position to be that much stronger, more efficient, and more equitable to all citizens of the state. So that's the reason for the request. That's the reason for the bill, and I'll stand for any questions that anyone might have.
Excellent. Thank you very much. And yes, your testimony was received. Kim has done a great job of sending out all of the bill briefs and testimonies in advance of our meeting today. So,
Thank you.
yep, absolutely. Committee, any questions for Chairman Bennett? Go ahead, Representative Wheeler. Of course, getting unmuted is always a fun time, isn't it, Representative Wheeler? There you go.
Am I unmuted?
You are.
Good to see you, Mark.
See you, John.
I haven't had a chance to get completely through this bill, and forgive me for that, because it's lost somewhere down in my email. But is this the bill that also provides for extension of the speedy trial right?
Different bill.
Okay, that's what I want to check to make sure.
That's House Bill, I believe, 2026, I believe it is. Now,
Are you going to testify on that tomorrow?
I am. I'll be up in Topeka for that tomorrow.
Okay, thank you, Mark.
You bet.
All right, Representative Carmichael, I see your virtual hand raised.
Thank you, Mr. Chairman. I hope you all can hear me.
Yes.
And I want to start out the same way my colleague, Representative Wheeler did. Hello, Mark. Now you can answer the same way and say, hello, John.
Hello, John.
It's nice to see you again, Mark. The bill, I think, on speedy trial is 2048, if I remember correctly. And I know you're planning to come to Topeka tomorrow, but I think the committee will be meeting virtually. I guess we're taking a vote tomorrow, but at any rate, you don't have to be here. I'm sure the chair would tell you. My question relating to this particular bill concerns adding a public defender as a member of the commission. And if I think back to a couple of years ago when we were forming this commission, we reserved a spot for a defense lawyer, a criminal defense lawyer. And quite frankly, it was my anticipation that the governor would appoint a public defender. However, she chose a good friend of mine from the bar here in Wichita, and I'm sure the committee benefits from her participation. But Mr. Bennett, as I've watched the committee and its work via YouTube and otherwise, I really haven't seen that this committee works as one where it's the prosecutors against the defense lawyers at all. It seems to me, at least, that there's been good collegiality and cooperation. And so I don't perceive this as a chance to load the committee in favor of the criminal defendant. Do you see it that way?
No, I think what we've tried to do is make sure all perspectives are included. By that, I'm talking about, for instance, so I'm there for the prosecution, largest office in the state. But Tabitha Owen is there. She's in Smith County, solo office, one person, just her. Her judge comes around, her district court judge comes around every 6 weeks or something. I mean, so it's a totally different perspective than an urban. And the same thing goes, private counsel is going to have defense counsel will have a different experience maybe than a public defender would. And so I think it was just an effort made. And frankly, it's one made last year even, and we just didn't get somebody appointed to make sure that the perspective of a public defender who, has no choice over who they take as a client, the volume of their workload, caseload, that perspective is included as well. But no, I agree with you. It's really been a very collegial. Everybody's on the same page. We all know what the issues are. We may not agree exactly on how to get there, but I just think having a public defender is an important voice on this effort.
And so I take it you would encourage the committee to put a public defender on the commission so as to expand the perspectives and in the end, hopefully produce a better product?
Absolutely. And I think the specific ask is so that Heather Cessna, the new bids chair, would I think be the person to appoint that selection. But yes, absolutely.
Well, the governor didn't listen to my suggestion last time. I don't know why she would this time, but thank you, Mr. Bennett, and thank you, Mr. Chair. Appreciate it.
Certainly. Thank you very much. Any other questions for Chairman Bennett? Not seeing any. Thank you for your time, Mark. We will move on to, it looks like, Nick Reinecker. Nick, we're ready to hear your testimony.
Can you hear me okay?
Can hear you just fine. Thank you.
Very well. Thank you, Mr. Chairman and members of the committee for allowing me to speak today. I know I believe it was August of 2019 when this commission got together, and I have enjoyed watching and observing and listening to the product that has kind of came out of this. I did have a couple of questions, and I don't know if this is something that would be possible on a commission as far as perspectives go, and the possible need or desire to have a member of the general public on the commission, and how that would affect the final product. Also, I know I've talked with members of the commission, including leadership, about before it was section, I think subsection 9, we're considering other matters. And I think that's a little too broad, and I'm glad that the scope is being narrowed. But I was wondering, regardless of what the legislature does this year, when it comes to cannabis, I was going to see if the possibility of that issue could at least be considered, whether it be pertaining to bed space or how it would affect down the line on the front end, diagnostically speaking, back end, or however you want to mince it up, that's fine. And if you could find a general consensus about that issue, you wouldn't possibly need a subcommittee. But just from a citizen standpoint, I think that is an issue that keeps on coming up, and might serve the citizens of Kansas to be talked about a little bit. As far as I just didn't understand the where is it here? B5B, create standardized terms and conditions for community supervision and provide for a method that courts may utilize to use special terms as indicated through the introduction of compelling evidence. I really don't understand what that means. So my question was, how does this relate to the DSM, SASE, and other diagnostic tools? And if it does, where does that play out on everything? So those were just my main concerns or thoughts on the bill. I am a proponent of it, and I'm glad that you guys are continuing on, and I thank you, and I'll stand for any questions.
All right. Thank you, Nick. Committee, any questions? All right. Not seeing any at this time. Nick, thanks for your testimony. Committee, I would also mention that we have written testimony from Jessica Glendenning of the Kansas Association of Criminal Defense Lawyers, and also written testimony from Randy Bowman of the Kansas Department of Corrections. So I don't see any neutral or opposition testimony. Anybody have anything to present there? All right. Well, committee not seeing any, then we'll go ahead and close the hearing on HB 2077 and move on to House Bill 2031, where we'll open that hearing and ask Natalie to provide us an overview.
Thank you, Mr. Chairman. House Bill 2031 would increase good time credit for certain offenders in the custody of the Secretary of Corrections. So the bill amends the good time statute KSA 216821 to provide that on and after July 1 of 2021, offenders incarcerated for a person felony would be able to earn up to 25% of the prison part of their sentence in good time. And offenders incarcerated for a non-person felony would be able to earn good time equal to 40% of the prison part of their sentence. It also provides that employees of the Department of Corrections may be liable for wrongful acts or omissions related to the calculation of good time credit. And I can take any questions.
Excellent. Thanks, Natalie. Any questions, committee? Boog, go right ahead.
Thanks. I didn't have time to run through the draft. Does this still include the increase in program credits from 120 to 150?
Let me verify that real quick. Yes, it does. Sorry, I should have included that in my brief, actually. So you'll see in if you go to page 3 at line 2, we're also increasing the amount of program credit the inmates can receive. Right now, they can get 120 days of program credit, and this would make that 150 days.
Thank you.
All right. Thank you, Representative Heiberger. Representative Resman, you have a question?
Yes, thank you, Mr. Chairman. I was wondering, is this the same bill that we heard last year, and is this the same 40% that was proposed?
Mr. Chair, Representative Resman, so you guys did hear a bill to increase good time credit last year. The bill as proposed would have actually increased good time to 50%. And so when you guys worked the bill, you made some changes to that bill. And so this new bill before you is how that bill passed out of House committee. So this includes the changes that you guys made last year.
Okay. All right, thank you.
Mm-hmm.
All right. Not seeing any other questions. We'll go ahead and move on to proponent testimony. And Scott Schultz, if you'd like to start us off with testimony, we'd appreciate it.
Mr. Chair, members of the committee, thank you so much. Can you hear me all right?
Certainly can.
All right. Thank you, sir. Thank you for the opportunity to testify in favor of this particular bill. This has implications as far as incarcerated offenders in our system right now, or actually going forward. But I'm going to go ahead and, if I can, which hopefully I can, I'm going to share my screen. Can you all see that okay?
Sure can.
So this is a combined non-drug and drug grid. For those of you new, this bill deals with good time credit that offenders can actually get while they're incarcerated in DOC. There is also a program credit component that is separate that I'll talk about in just a little bit. So knowing the differences between good time credit, program credit is kind of key in this particular bill. But what you're seeing is the non-drug and the drug grid. Right there where I have circled in green are the current good time credits, and they're based upon severity levels. So if you recall, a level 1 on the non-drug grid all the way down to 10, that is from the most severe to least severe. Similarly, on the drug grid, your severity level 1 is the most serious offense to the level 5, which is the least serious. And so you can see as it sits right now, an individual that is placed in DOC custody will get 15% good time credit for those more serious offenses. Most of those are normally person felonies. And then for the less violent offenders or non-person, a lot of them are then 20%. We had originally, the Sentencing Commission had originally brought, as Natalie indicated, the bill that would provide 50% good time credit. That was massaged, and when this bill was worked to this particular proposal, which even at these levels, the Sentencing Commission overwhelmingly supports. What you have is then that a bill that basically is the same as what you passed out favorably last year. So what I kind of wanted to talk about the overarching concept of this, and I won't take too much of the committee's time, but the overarching concept of this is, and I talked about this a couple of weeks ago in my presentation, we're looking more at incentivizing offenders, and whether or not that's, in this case, the bill that's the folks that are in prison, but also then we have other bills that folks that are on probation need to be incentivized. Those of you that, and I tried to think of some type of parallel for this, that most of us don't have a criminal mentality, but But a parallel to this certainly could be looking at it if you've ever supervised or you're currently supervising other individuals in your as part of your vocation, and many of the times you have to look at do performance reviews, those type of things, and so that actually requires you as a supervisor to set expectations for those employees. And many times, and best practices obviously say, write those down, let the employee know it so that you can, so they know exactly what they need to do to meet your expectations or exceed them. And so this is a similar situation. Right now, offenders have the ability to have this good time credit. We're just simply increasing that in this particular bill to 40% for those non-persons and 25% for the person felonies. It does not, and I will underscore that, it does not affect the off-grid folks that are convicted of murder, child sex crimes, those type of things. They do not receive good time credit on their time, so it would be only those offenses that are on the grids. So they don't currently, and they wouldn't under this bill be receiving good time credit, those off-grid folks. So part of my testimony, it's kind of interesting. You know, I used to think, even as a almost career prosecutor in my past, that good time credit was basically if you fogged a mirror, you could actually, you know, you're going to get it as soon as you were sentenced and away you went. That's not necessarily the case. If you read through my testimony, DOC has a process and procedure in which they implement looking at these each of the offenders and inmates on a 120-day period. And they have the ability to take away good time credits, up to 100% of the good time credits during that 120-day period. They also have the ability, if the offender decides to reform and be compliant, to actually give that credit back. So it isn't just a matter of just because you step foot in the prison, you're automatically getting this credit. Some of those things that they're looking at to make the inmates in that determination as far as awarding those good time credits include performance in the work assignment, performance in the program assignment, maintenance of your group living environment, participation in release planning activities, which is very important in the reentry process, your disciplinary record certainly, and then other factors as far as behavior, attitude, and those type of things. So it isn't just a carte blanche, you're going to get it. And so again, this allows for the inmates to be incentivized as to they know that they potentially could be released earlier. And isn't that really what we're looking at in terms of we want them to comply, we want them to work their programs, if they have work assignments, we want them to do that. It also provides for more effective case management as far as KDOC is concerned, which is, you know, that's logical, it makes sense. But keep in mind, this is one of those things that it certainly allows for them to have something a goal to actually be able to know what the expectations of them are. I did put a few paragraphs in there, just a general situation as far as reviewing the relationship between the length of sentence, incarceration, and deterrence, based upon a couple articles from the Pew Charitable Trust. They have a particular study that I cited that indicates where nonviolent offenders are involved. Analysis of data from 3 states found little or no evidence that longer prison terms for many nonviolent offenders produced either incapacitation or deterrent effects. And so when we're talking about it, you know, this bill kind of puts you in a situation where you have to weigh the exorbitant cost of housing offenders and whether or not they should, if they're doing what they're supposed to be doing and they're getting the credit they're supposed to be getting, should they still continue to be housed? And so that particular study talks to that. I have another citation as far as public opinion indicating that nearly 90% support shortening prison terms by up to a year for low-risk nonviolent offenders if they behaved well in prison and completed programs. 80% of the poll respondents from households in which someone had been a victim of a violent or nonviolent crime agree with the statement. It doesn't matter whether a nonviolent offender is in prison 18 or 24 or 30 months. What really matters is that the system does a better job of making sure that when the offender does get out, he is less likely to commit another crime. Again, another point in the bullet point here is certainly officer safety is also a consideration, and when we had it certainly can contribute to officer safety in terms of fewer inmates in the correctional facility, less likelihood then of violence to corrections officers. Finally, the program credit, and I'm getting to it. Program credit is different from good time credit in that it requires the offender or inmate to actually be intentional in terms of completing certain things such as vocational training, drug and alcohol treatment, anger management, those type of things that that the legislature has previously said if you do those things, you will actually get credit on your sentence. The current amount at this point is 120. This committee raised it to 150 last year, and so we certainly support that as well in terms of the timing that allows the individuals. Now, keep in mind, as far as program credit, this is similar with the good time credit. There are certain offenses that are more serious offenses that are not eligible for program credit. So keep that in mind. But again, it just allows yet another method for incentivizing those offenders to complete programming, which will enhance the likelihood of their success upon release. As you probably noticed from the, let me stop sharing this. Probably noticed from the impact, this is a prospective bill that would, starting on July 1, and the Sentencing Commission is estimating 85 prison beds would be saved, all on the way to 564, which would be a major bed savings by the end of the 10-year period. This is not retroactive. I know that probably, I'm not sure whether that was a consideration as far as the Joint Committee on Corrections and Juvenile Justice when they pre-filed this bill, but that was our intent, and certainly we think that should stay that way in order to preserve the plea agreements and those type of things that have already happened with the current inmates that are already there. That was done by agreement, many of those probably by the agreement of the parties and with the understanding that those individuals would be getting 15 or 20% rather than this new proposal. So this would be a prospective. Any folks that now are committing crimes on or after July 1 of 2021 would be subject then to this particular bill. Thank you so much for the time. I'm happy to stand for questions at the appropriate time, Mr. Chair.
All right, thank you very much, Scott. Looks like first up we have Representative Carmichael with a question, and then we'll go to Representative Wheeler.
Thank you, Mr. Chairman. Mr. Schultz, I note that this bill deals with more than just good time credit, that it also provides that DOC employees shall not be liable not only for their negligent omissions, but for their wrongful conduct in the calculation of good time credits. Why?
Representative, that would be something that I don't know that I know the answer to that question. The Sentencing Commission certainly did not, originally propose that be included in there. I don't. If somebody's from DOC, that would be probably more appropriate to pose to them. But I don't want to. I certainly don't want to miscommunicate anything that the DOC would be thinking.
And I appreciate that. I didn't think it was your idea. My recollection is that's why I had to vote for the bill a vote against the bill the last time around. And I just wanted to make sure that is not part of what the Sentencing Commission is proposing.
That would be correct. I think that was in the bill, I think, originally, though. Certainly.
It was, and I voted against it, as I recall, for that reason. Well, I'll wait and see if we can find somebody who can explain why it is DOC should be insulated from wrongful conduct in calculating good time credits. Thank you.
Thank you, Mr. Carmichael. Representative Wheeler.
Thank you, Mr.
Representative
Chair.
Owens, I'm sorry, I hate to jump in. I want to just clarify actually what right now in current law, DOC is insulated from wrongful acts or omissions in the calculation of good time. What this bill does is strike wrongful. So they would no longer be immune from liability if they do make wrongful calculations in good time, just to clarify.
Thank you for clarifying.
If I might, Mr. Chairman, then I must have misread the bill brief because I thought it said the opposite. I'll look at that. Thank you.
Yeah, thank you. Thanks for the clarification. Representative Wheeler, go ahead.
Thank you, Mr. Chair. This question comes from me going all the way back to my law school clinic years back in the mid-70s. So I would like to ask Mr. Schultz, if there is a disciplinary action taken against an inmate charged, do they have a due process right to a hearing on that alleged disciplinary action? And if so, is counsel available?
Representative Wheeler, that would be a DOC question, and I apologize. I would love to try and answer it, but that would be something probably that, and I don't know whether or not if Randy is still on, he may be able to get you an answer on that. I apologize.
I appreciate your answer. Thank you, Scott.
Thank you. Randy Bowman is actually next up to share his testimony. So he heard that question and hopefully can address that for you as well. So with that in mind, if there are no other questions for Scott, we will go ahead and turn the time over to Randy.
Good afternoon, Mr. Chairman, members of the committee. Hope the sound and video is working okay. My first time before you this session, so good to see y'all, and I always appreciate the opportunity to speak with you for a few moments. Our testimony, which I assume you have that document with you. I won't go through it item by item, but would mostly just summarize. I think Scott covered this piece of legislation very well, and the secretary being a member of the Sentencing Commission, along with the Prisoner Review Board, Jonathan Ogletree. We've been actively involved in those conversations and appreciate and support the interest in this concept. The couple things I would just kind of double down on, I guess, since Scott covered them so well, and then I'll try to come back to that question best I can. Really, in our view, this is about acknowledging the behaviors of those who engage in the pro-social types of behaviors while they're in a facility that we all hope they will do. And then, of course, hope they will translate when they come back out in our communities as our employees and our friends and our neighbors and in our churches and in our grocery stores. It's an opportunity for them to learn the behaviors, demonstrate that they can sustain them over time. And then it lets us focus the limited amount of resources that the Kansas taxpayer can afford to invest into a prison system more appropriately to those who are not engaged in those behaviors. So keep those limited prison beds for those that, for whatever reason, we have not been able to reach them or they have not seen any wisdom in changing their behavior. Let them serve their full sentence, but let those who do change their behavior earn their way out of prison a little bit sooner back into the community is a valuable tool and policy in our view. Then second, we just footnoted, and I think we did this last year in our testimony too. Sometimes people view public policy as a pendulum going from one side to the other. So last year, as was articulated by Scott and others, The bill was originally proposed 50%, which matched where we were 25 or so years ago. And then in committee work, you ratcheted to the current proposal here of 25 and 40. So seems to us a little bit we're hitting that middle ground over the last 25 years, from 50 clear down to 15, kind of 15 and 20, so back in that middle. So we just wanted to footnote that historical item from 1993 and prior for the committee. With that, that was all I had planned to comment upon, but getting to the question of is there a process when they lose that time? We have a policy and procedure on how that works, Representative. That's a little bit detailed. It's about 3 pages in duration, and I have it in front of me. Looking at it here, there's various levels that goes through the department, starting with their unit team counselor, their manager. It can come clear to the secretary or his or her designee for review of that stuff. But I don't see anything in the policy and don't believe I've ever heard talk about them being represented by counsel in this process. And with that, I would stand for additional questions or try to dig more on that topic.
Excellent. Thank you, Randy. John, Representative Wheeler, did you have a follow-up question there?
Just a quick follow-up, and it may or may not be important, but it is historical. Because back in law school, back in the mid-70s, we had a clinic that periodically would travel to Lansing to represent inmates on disciplinary proceedings. I just wondered if that is still available. And it's not really all that important. Things change along the way, but it used to be that way. And law schools law students get a lot of representation.
Let me do a little research with somebody who's a better historian, and I'll send that back through committee staff if that works for you, Mr. Chairman.
Certainly.
Okay.
Representative Carmichael.
Thank you, Mr. Chairman. I might volunteer in partial response to Representative Wheeler's question that when I was there in 79 through 82, we were still going to LSP to do disciplinary hearings, but I believe that the institution discontinued that some years later, but we'll have to wait and see. My question, though, for our conferee is, why does the Department of Corrections need immunity if they miscalculate good time credits? Why shouldn't the DOC be liable under the Tort Claims Act like any other state agency is when they deprive people of their rights? And secondarily, I'm still not sure about whether this does or doesn't include conduct beyond negligence. I would hope you could address those topics for us. Thank you.
Yes, Mr. Chairman and Representative Carmichael. As I understand the history on this, it's been there for some time, and I don't believe we've weighed in on this subject this cycle or the previous cycle on this matter. But just looking at it, not through to my lens, it's not as an attorney. It would seem that if we made those errors, ultimately the taxpayer is going to pay out some sum of money for that. So maybe somebody proposed this law historically to limit those financial costs to the taxpayers.
So then this request for immunity does not come from DOC. It's somebody else out there who's asking for this relief. Is that correct?
Well, as I understood, the revisor's often explained it's already in there, and we're actually backing it up just a little bit in this proposal.
Well, I guess what I'm pointing to is whether it's there today or not. I'm trying to figure out whether it needs to be there. And from DOC's perspective, it sounds like you don't need that immunity. Is that right?
Well, I'm sure our lawyers would like less work, but I think ultimately it's a policy question of what's right for the citizens of the state. So we'll be okay with it either way.
I appreciate that, Mr. Bowman. Thank you. And Mr. Chairman, I appreciate that you let me ask that question. I guess I'll keep asking it until we find somebody who can justify why it's in the statute. Thanks.
Mr. Representative Owens, I just maybe want to attempt to clarify this again. If you guys can look at the bill on page 3 at line 30. So right now that immunity provision states that the secretary shall not be liable for any damages caused by negligent or wrongful acts or omissions in making the good time and program credit calculations. So what this bill does is strike or wrongful. So now that immunity, they will still be immune for negligent acts or omissions, but they will no longer be immune from liability for wrongful acts and omissions.
All right, thank you for clarifying. Hopefully we've taken another step in the right direction to understanding that piece. Representative Heiberger, I believe you have a question.
Just a comment relative to the disciplinary hearing question. Being somewhat younger than some of my other esteemed colleagues, I was in the Defender Project in the early 90s. At that time, we were not doing disciplinary hearings.
And I was just going to add that, you know, back in '82 when I was in kindergarten, I don't remember them either. So, all right.
And for the record, I don't recall representing you at any of those hearings, Mr. Chair.
Thank goodness. Thank goodness. All right. Any other proponents wish to speak here today? If not, we'll go ahead and move on to our neutral conferee, which is Chairman Bennett, DA Bennett from Sedgwick County.
Thanks, Steve. So back at it. I took a neutral approach on this because kind of in an odd spot here as the chair of the commission. I know that it was something I included the reference to this in my written testimony. The chairman or the Reform Commission said that we wanted the legislature to consider the Center for State Government. They did quite a bit of research for us in the commission and had a lengthy report that was attached as part of our final report. And they had recommendations listed at pages 53 through 56 of the appendix. That was their report was an appendix to our report concerning violent crime, sentencing, and victims assessment. And so there was no consensus on the Reform Commission as to exactly what kind of increase or changes to good time there should be. But we did recognize it was an issue that the legislature needed to take up. Add to that, I also am the district attorney of largest jurisdiction in terms of cases that enter the system in the state. And I'm also a former president of the DA's Association. I know that they're not supportive of this legislation. So Criminal Justice Reform Commission wants you to consider the totality of it. I think the DA's Association is probably not on board with this. So that's why I'm neutral. I'll make a couple of points here that I've made in my written testimony. One is, and I think this, Mr. Bowman referenced this a moment ago, so I look at the historical look back. Pre-93, criminal sentencing was in what they called indeterminate ranges. So you'd have a 3 to 5, a 5 to 15, 5 to 15, a 15 to 30. That would be the sentence. And so when you walked out of court, well, how much time is the guy actually going to do? And it was unknown. The guy could do the full 30 years, 20 years, whatever it may be. But he was eligible for up to 50% good time. I believe it was 50% back in those days. And that was, up to the parole board, determining if he had, met certain markers, he or she. And, I think that the consensus was when we passed the grid in '93 that we would have what's called truth in sentencing and have a determinate grid. So when the guy gets sentenced today, you look at your grid, and if it's a criminal history I and a severity level 1, they get mid number. It's 155 months, and that's the sentence. Well, how much good time could he get? Well, if memory serves, when the grid was passed in '93, when the sentencing guidelines were passed, it was 10%, and then a few years ago we bumped it up to 15%. If it's a level 1 down to a level 6, I believe, on the non-drug grid, and it was 15% for other cases. Now it's 20%. So we've moved our way up a bit, but I know the discussion in terms of this effort to increase good time. I understand incentivizing. I think that helps the DOC in terms of management of the inmates and trying to get people out and encouraging them to be better citizens upon their return to society. But I would point out that there's a couple of other things to consider here. And I noticed, I think it was maybe Scott who talked about the public opinion discussions and, whether someone's got 12, 18, 36 months, they can get some shaved off if they're behaving and they're getting the help they need to be a better citizen on the back end. The reality, though, is there's a whole lot of folks who enter the DOC finally after, especially on non-person crimes, only after being placed on probation and having multiple violations of probation where they earn jail credit in the local level. And so I think the last numbers I had was from 2017. Scott's probably got more recent, but I don't have any reason to believe it changed significantly. In 2017 numbers, I believe it was based on the 2018 Sentencing Commission's report, 21% of people entered the DOC owing 6 months or less, and like 70% owed 5 years or less. And so if we're going to start, cutting things in 40%, that constitutes a pretty significant reduction in their sentence. And I suppose that's why we're going to have some 500 beds saved over the course of 10 years. I mean, there's a lot of folks going to do a lot less time if this is in place. And I'm not advocating for more time, but I am advocating for, let's take a minute and consider this. If someone enters, I mean, I'm just looking at the grid right now. You don't get to even a 12-month sentence on a severity level 8 or 9 until you're up to criminal history F or E. And then on level 9, it's not until you have at least a 1 prior person felony and you're a D. So this is there's a whole lot of folks who won't even see double-digit sentences on level 9s, level 8s. Level 7s, it's 11, 12, or 13 months on the front on your first offense. But if we reduce that by 40%, I guess my point is, at what point are we want to incentivize the behavior of the people who enter the penitentiary. But if we reduce the ultimate penalty so much that by the time I get there, I owe almost nothing, are we almost incentivizing people to not care at all about the sentence they owe? I don't want to add to a bill that's already been thought through here. And obviously the Sentencing Commission's on board, and they, I mean, understandably, this will, the bed space implications and the hope that it impacts people's behavior positively, are significant. But I have concerns that if we reduce it to the point that there's really, I've heard the old expression, I can do that time standing on my head. I mean, I might as well just go and do my 30 days or whatever's left over and get right back out. And so I think we do reach a point where we reduce things so much that we almost disincentivize good behavior. So, I mean, if there could be some caveat that whatever amount you all reach, it only applies to people who actually owe, 6 months or a year or something upon their arrival, so that the whole point of this is to incentivize good behavior, could actually be accomplished. I mean, if I arrive owing 6 months and you're going to cut 40% off, do I even have time to go through these programs or behave in any way that give you an indication that I'm on board? So you get my point. I guess the big picture I'd say is, I understand that incentivizing good behavior is impactful. We also, though, realize that 70% of people in Kansas are sentenced to probation. I mean, think about that. 70% of people who walk through the courthouse doors walk out on probation, and still we have 10,000 people in the penitentiary, which tells me there's a whole lot of folks who aren't doing well on probation. And if they didn't get the picture that the threat of going to the pen wasn't enough to incentivize their behavior while they're out living at home and working a job and doing other things, I'm concerned that they're suddenly going to get with the program the minute they arrive, when, like I said, 70% of those folks arrive owing 5 years or less. Big picture here, there's a balance to be struck. And as the chair of the Reform Commission, I do understand that. And I also understand that the legislature and Kansans do not want us to continue to build bigger prisons and more prisons. But at the same time, I think we need to be careful about giving people sentences in court and having them cut 40. I guess last year that was 50% was the proposal, but 40% later on administratively. I have, as a prosecutor, have concerns about that. So what's a good balance? Obviously, is I'll parrot what Mr. Bowman said a moment ago. I mean, some of these things really boil down to a public policy question for public policy makers and you all. But it strikes me that for person crimes especially, 25% cutting their off by a quarter is an awful lot when somebody has been hurt. when to earn a person crime, some human being had to been the victim of that specific crime. On the property crime, again, I understand why there's less reason to oppose it. But again, as I already said, many folks enter the penitentiary system for property crimes owing not a lot of time. So moving up from 20 to 25%, something like that. Maybe step this up, see what it does to us over the next 3 years, and revisit the issue would be my recommendation. So again, I'm walking a fine line here, trying to acknowledge and a tip of the hat to the effort and the need for this discussion and a robust conversation about this as a member of the commission. But I know on behalf of prosecutors, there's concern. So I think I've hopefully made my point, not been too ambiguous about it. And I'll stand for any questions you might have.
Excellent. Thank you, Mark. And I'll indulge and ask a question myself here. So you're kind of unique. You touched on this briefly, but you're in a unique position as it relates to the victims of crime and being able to hear from them. It seems like oftentimes we don't hear enough from those organizations because there are crimes victims organizations out there as it relates to some of these policy things. Anything that you could add, any context that you could add from a crime victim's perspective as it relates to a bill such as this?
Well, I think people are, it depends on the crime. Obviously, we're talking about the whole scope of crime. I'm the victim of my family member had somebody pull a gun on it. That's an ag assault. There's, I'm concerned about anybody getting anything less than what the judge said. So I think the more violent crimes, there's a lot less of a public support, victim support for any protection of any. Frankly, what we get most times is, why aren't they doing more? On the property crime notion, again, I think people are supportive of less time. I always hear people say we should have fewer people locked up on nonviolent crimes. Like, okay, great. And I don't disagree with that, but that's the case until I get called down and have to go to a community meeting where everybody's mad as hell. The cops arrested a guy for breaking into sheds and garages all throughout the neighborhood. And why in the hell isn't he still in custody? And I go, it's a non-violent crime. No one got hurt. He broke into my home. I understand that, but it's a level 9 burglary because it was a garage. You weren't home at the time. And he's going to get a very low bond set because he's going to be presumptive probation. And just as a kind of a parenthetical, I have not seen as much social media chatter about a criminal justice issue in the last 90 days. Now, summer was a different conversation, but the last 60 days was, as I have about a guy down in Barber County, Medicine Lodge, who got arrested in Harper County, both counties prosecuted for poaching 60 deer, and he got a 14-month sentence. And everybody was, good for the game wardens for getting him, but what idiot let him off on 14 months? And I'm thinking, I feel bad for the judge because I'm sure they threw the book at him. That would be the maximum sentence you could get. So I think everybody's supportive of non-violent criminals getting less sentence until it's their shed, or it's their garage, or it's the deer, animal abuse crimes. People really get upset about when they find out the de minimis penalties for that. And I get hate mail. Why the hell is this guy getting a misdemeanor? It's like, well, let me show you the law. And so I'm not trying. I hope I'm answering your question, but it's a moving target. But I think the hard line I could take is that the person crimes, when someone is a victim of a person crime, there's very little support that I've ever seen for a reduction of their sentence in any way, shape, or form. Now, when I explain to them, look, they got to give them 15% because they got to be able to manage these folks in the prison. If nothing I do changes one iota the day I get out, what incentive do I have not to be the biggest pain in the ass possible? Sorry to be so blunt, but that's the conversation I have with the victims. And they go, okay, I get that. And they understand why good time is a part of this equation. But on the property crimes, it's more of a mixed bag.
All right. Well, thank you for that. I believe Representative Smith has a question. You're muted, my friend. Isn't technology grand? Let me see if That help you?
Yeah, that helped. Had to get out of that chat box. Sorry about that. Mr. Bennett, I appreciate your testimony, and you couldn't hear me on the other end. Apparently, I couldn't get out of it anyway, but saying amen on a few things you had to say. That's just the way that goes. But, one of the things I think that you brought up that interested me was the number and how we got to the number and whether it's appropriate. Throughout this, I've just tried to overlook my own question of, is it an arbitrary thing? How did we come up with it, what it is? Now, I know it went through a process last time where we dropped it from 50 to 30 or whatever it was. So I'm not necessarily, I'm like you, I'm not necessarily against the idea on the non-person misdemeanor or felony crimes. And I'm not against people getting good time. And you throw out some really good information there. What I am concerned about is those folks who are heading back to prison for doing the same crime. And why should they be eligible for good time when they're just doing exactly what they served time for before? Aren't we running into the same problem on there? Does that ring a bell with you as that would be a problem or the same type of problem?
Let's put it this way. The approach from this bill is understandable because it's fairly simple. I mean, it's even more simple, frankly, than existing law, where it's based upon a severity level, and level 1s through 6s is 15%, and 7s below, or 20%. And this is just person crimes versus non-person, and it's a very straightforward approach. To get at what you're talking about, we would have to break this down a bit and add some wrinkles to this bill. So you could say somebody who's a criminal history D or below, or say E or below. So it means they've only got non-person violent crimes or non-person crimes in their past. They would be eligible for, a higher level than somebody who's got a person felony in their past. Or you could get more granular and say someone who has not had a person felony in 15 years. Does it matter that I got in a bar fight in 1986 and got and won? And so I got an ag battery there, and suddenly for the rest of my life, I'm not eligible for good time. I mean, maybe you want to break it down even further and talk about the age of my priors. I mean, there are ways to get at what you're talking about. And frankly, it would be a heavier lift. It would put more burden on DOC to move all those factors around. But it would certainly be something that would be more defensible to law enforcement, prosecutors, and frankly, victims groups. That being said, let me just end it there. So that's the only way I can see getting at what you're getting at. It is to be more specific in the statute, have a balloon amendment or something that talks about some of these things. If I'm back as a repeat offender on the same type of crime, if I've got criminal history, if I've just gotten out of the penitentiary within we have people all the time who commit new crimes. They've been out of the pen on parole for 90 days. Somebody like that, you go, you know what, maybe they've lost their, but then again, they get into
Mr. Bennett, I'm thinking more along the lines of the individual who has spent time for doing 10 burglaries before and then 10 burglaries before that. And now we got them for 15 burglaries. And why are we going to give them good time on their third trip in, that kind of thing? And yes, I understand that, there are already built in, for the previous history. And I'm also thinking that maybe the PSI is where you catch that and you just set it up from there.
Yeah, PSI is where the criminal history will be laid out. And I mean, what you're talking about is essentially a judge would have to make a finding maybe to say you would be eligible for good time because your criminal history is thus and such, and your history is thus and such, your age is thus and such, or your age of your history rather. But again, that's not contained in this bill right now. It would have to be something that would be added in significantly.
Excellent. Thank you very much. Let's see. It looks like Representative Carmichael has a question.
Thank you, Mr. Chairman. Actually, I have an admission and a correction to make. I misread Ms. Scott's bill brief regarding wrongful conduct. My apologies to everyone for confusing the issue, especially Ms. Scott. I'm sorry.
Duly noted. Any other questions for Mark? All right, seeing none. Any other neutral conferees or opponent conferees wish to speak on behalf of this bill? Seeing none, and we'll close the hearing for House Bill 2031 and move on to the final bill of the day, which is House Bill 2029. and ask Natalie to give us an overview.
Thank you, Mr. Chairman. House Bill 2029 would count crimes designated as a domestic violence offense as prior convictions for the purposes of domestic battery. So current law in KSA 2154-14 provides that domestic battery is a Class B person misdemeanor, then a Class A person misdemeanor on a second conviction in the immediately preceding 5 years. And then it goes up again to a non-grid person felony on a third or subsequent conviction in the immediately preceding 5 years. So current law requires those prior convictions to be for domestic battery specifically. And this bill would count any criminal offense that includes the domestic violence designation pursuant to KSA 2246-16. That's commonly referred to as the DV tag for those of you familiar with that concept. So it would count all of those as prior convictions for the purposes of escalating this penalty here in domestic battery. And I can take any questions.
Any questions, committee? All right, seeing none, it looks like we have Ed Klump set for oral testimony, but I'm not seeing him on the call. Is it possible that he is in the committee room?
That's a no.
Okay, I wasn't sure. I haven't wasn't 100% sure there. So, Representative Heiberger, did I see you have your hand up?
Yeah, I just have the question for Galloway. I didn't get in in time. Did we work this last year? And if we did, what was the result?
Yes, you did work on this last year. Forgive me. I should have brought all of these up previously when so it was House Bill 2518 from last year, and you guys passed it out of committee without making any amendments, and then it passed out of the House floor 125-0. The hearing in Senate Judiciary got canceled. It was scheduled for March 18th, so it looks like it got canceled probably because we left because of COVID.
All right. Well, with not seeing Ed here to testify, we'll go ahead and commit his testimony that you should have received as written. We also have written from Jennifer Roth, the Kansas Association of Criminal Defense Lawyers, and Randy Bowman of the Kansas Department of Corrections. Mr. Bennett, you've testified on about everything else. Do you have any comments or anything you'd like to add to this one?
Oh, I appreciate it. Make it brief. I think Tabitha Owens, the Smith County attorney, also a member of the Reform Commission, submitted written testimony, and I let her know that if she was stuck in court, I'd say a few words on her behalf. This is something that's really a policy question. I think later, several years ago, there was an effort made to address domestic violence in the state. And one of the things that occurred to everyone is that not everything that the only way we really could address previous to adding the DV tag to crimes, the only way we could address domestic violence was if it was a domestic violence battery charge, DV battery. Any other thing that took place wasn't designated, didn't have any special designation as domestic violence. I would tell you that advocates, supporters of folks who have been through domestic violence, been victims of domestic violence, and those who help both the, I say the women, is primarily females, it's not always, and the families though, understand that that domestic violence is still very much an issue in Kansas. We have spent a lot of time, and justifiably so, over the last several years talking about the need for improvements in mental health and drug treatment. It is really probably the most overarching issue in the criminal justice system right now, and justifiably. If we could get our hands around those two things, we would make a significant impact both in the criminal justice system and on society at large. I would say there's one other issue, though, that's not a second tier or third tier, but it's just one that hasn't gotten as much publicity of late, and that's domestic violence. And I will just tell you one quick anecdote and then try to wrap this up. But we've had, it's no secret, we've had an increase in violence in the city of Wichita. And that mirrors an increase in violence in several major cities around the country. I don't remember what the final tally was at the end of 2020, but 3 dozen cities in America hit their all-time high for homicides. Not a record you want to break. But we did in Wichita. We had 59 homicides last year, which was the most we've ever had. And one of my assistant district attorneys about 18 months ago sat down one afternoon and wanted to follow a hunch that she had. And she ran every name of every defendant and every victim of every homicide that had occurred, I believe in 2018, through our local database. Not the national FBI and CIC, just WPD, SO, Sedgwick County District Court, just ran their names. And what she found was that of all the homicides that year that we had charged, and it was over 40, all but one of those people had been listed in a previous case as either the suspect in or the victim of a domestic violence case. Not even against each other, but just somewhere in their past, domestic violence had touched them. And there is a understood, if you work in the criminal justice system, and frankly, I think sociologists and psychologists who study trends would echo this. There's an understanding that family violence is one of the most direct precursors or an indicator of future violence that a kid may have growing up. That it's no secret that 80% of females who were killed are killed by their a spouse, a boyfriend, a former love interest. And so what I'm getting at is domestic violence is a very big deal. And so the public policy of the state has long been that people who can be tagged, have a crime tagged as domestic violence, and that is something that's for future reference, for future judges, for conditions of probation, etc. One thing we did not ask at the time, and that was not contemplated, was should that count the same as a prior for enhanced sentence purposes? And that's really a question for you all. Is that something we want to do? But I do believe it's in the interest, of the public interest, especially when it comes to public safety, to add this bill. One point I would believe the bill contemplates any case that's tagged as DV, and I think, as Tabitha and I discussed last week, I think a distinction could be made between person and non-person. If it's a non-person crime that's DV tagged, which could happen, destruction of property or something like that, it would otherwise be a non-person crime. He comes over and slashes her tires. It's a domestic violence. It can be tagged as domestic violence, criminal damage to property, domestic violence. Whether you make that include a non-person crime in this categorization or not, again, I think it's another level of discussion. I don't know that that's necessary, but I don't know that it's not. Again, question for you all. But we would ask you to give strong consideration to this, because I think it fits in line with the state's overall public policy that we want to do all we can as a society to deter domestic violence and do so by way of holding those who do it habitually accountable by holding them to account for their prior bad acts that are of the same nature. Just for the final thought, piggybacking on what Representative Smith said a moment ago, somebody who does the same thing over and over again, that there should be some accounting for that. And if you've got a prior DV tagged violation, we believe that should count toward your criminal history the same as if you punched somebody and got a DV battery. So that's the nature of it. The Public Tabitha asked for it by the Criminal Justice Reform Commission and its proportionality subcommittee, talking about what is proportional, agreed that this is something we would endorse. And so I'll take your questions if you have any. Thank you.
Mark, I believe Representative Carmichael does have a question.
Thank you. And by the way, Mr. Bennett, I generally agree with you on this. I was hoping you could give us some other examples, though, of the types of offenses that would now, under this bill, that would qualify for sentence enhancement. You mentioned the criminal damage to property in the domestic context. What other types of things are we talking about here?
Sure. So as it stands now, the only way you get a enhanced your current crime language enhanced by a prior is a domestic violence battery. So let's say that the crime that occurred, well, the example Tabitha gave in her written testimony, she prosecuted a guy for a strangulation case. Well, that's now an ag battery. This legislature amended that a few years ago to say that strangulation is in and of itself its own type of aggravated battery, because we understand the lethality that is a part of those types of acts. You put your hands around somebody's neck and strangle. I mean, where else do you go from there? The next step is going to be a homicide. And so, but that ag battery by strangulation is not a domestic violence ag battery. It's just an aggravated battery. So if he gets convicted of aggravated battery, has a D criminal history. But at the same time, it's not a DV situation. It's not just DV. The next time down the road, when he gets his second DV battery, the next time it's not as bad. He just pushes her. That prior counts obviously as a person's felony. But if he's convicted of a DV battery, it's B or Class A, and it doesn't enhance the current crime as a third time domestic violence battery or a second time domestic violence battery.
Well, I remember the good work that Ms. Parker, formerly of your office, did on the strangulation statute. But so in this so does that mean that we will look behind the journal entry, i.e. the crime that someone was convicted of, to look at the facts and circumstances to see if they're eligible for enhancement?
It has to be actually, no, I don't think you can do that. The prosecutor would have to allege it in the charging document. Court would have to so find, and have to be a finding made at the time of sentencing, same way like a firearm tag, a crime committed with a firearm. So it would not be a thing that we'd have to divine what was meant and whether it really meant. It's something that has to be alleged in the charging document and found so that it's a part of the journal entry.
Okay, I guess what I'm thinking about, you're saying it has to be pled and proven in the currently pending prosecution, that we will go back to the facts and circumstances of that strangulation and show it was in the context of domestic violence as opposed to a circumstance where somebody's just a strangler.
Well, I don't think there's any way to go back. I mean, it would only affect crimes moving forward. If somebody wants to, take another approach on this, I'm all ears, but I don't know that we could apprendi in that line of cases from the Supreme Court say that basically you don't get behind a prior conviction to divine what was or was not a part of that prior conviction. It has to be alleged and proven. So I don't think, and if I'll confer with her, and if she has something different to say, we'll submit some additional written testimony and make sure no one makes an uninformed decision. But I don't know how we could go back in time. It would affect cases moving forward. So that DV, we could make a DV on the strangulation case or a criminal threat and say, all right, that's a DV tagged strangulation. So in the future, if the guy gets a misdemeanor battery DV, we can go, wait a minute, it's not his first DV scenario. He has this prior that's been proven post 2021, and now that could be used to enhance future crimes. But to your point, I do not believe there's any way to go back and retroactively get make a new finding.
That addresses my concern, and believe me, I think there are circumstances where I wish we could go look behind prior journal entries in a whole bunch of context, but we can't do that. And what you just said makes very good sense. I appreciate it.
I'll just last thing, I don't want to overdo this, but if a judge made a finding of some kind, I couldn't say it couldn't be done, but it would be a tall order to try to find something like that.
All right, thank you very much. Thanks for all your time, Mark. Any other questions at this time? If not, I don't see any neutral or opponent testimony to this bill. If there is any, please let me know. And with that in mind, we'll close the hearing on this bill. And I will turn the time over to Chairman Jennings for just a couple of minutes as he wants to share some thoughts.
Thank you very much. I appreciate you stepping in and taking a lead here today as I cross the state. I enjoyed listening to testimony of witnesses and just want to remind committee members that tomorrow we do have on our agenda one hearing, and then we will be working three bills: House Bill 2026, 2027, and 2028. I'll remind you that if you have an intention to offer amendments to any of these bills, please get with Natalie Scott and have those prepared. While it is not a rule or requirement, I have found it helpful in the past If members can give me a heads up if they have an amendment, it's always nice if they share it. If you choose not to, you don't have to. Sometimes those lead to discussions and perhaps refinement. Otherwise, I would just say we plan on working those bills, assuming we have the time to do so. And then as to particularly House Bill 2077 that was here today, and do intend to bring that up Wednesday for committee discussion along with several others. So that's it for me.
All right. Thank you very much, Mr. Chairman. And unless there is anything else that needs brought before the committee, we will consider ourselves adjourned for the day. Have a great rest of the day, guys. Thank you for attending.